Now it's the time to give the floor to our third panelist, Liemertje Sieders. Lim is a New York qualified attorney with experience working as a litigation associate, as well as compliance specialist in both the energy and technology sectors. Lim specializes in financial crime, corporate social responsibility, gender equality, and business and human rights. The presentation is entitled Technology in Human Rights Supply Chain Monitoring, Opportunities and Risks. Welcome, Lim. Please, the floor is yours.
Thank you. Thank you so much, Donato. Thank you for this wonderful invitation, to all of you for organizing. It's already been super interesting to hear the first two panelists share their thoughts and kicking this off. So thanks so much. I'm going to share my screen. So thank you, Donato, for the introduction. I have worked previously as a litigation associate in economic crime and then moved towards developing an expertise as compliance specialist in multinational companies and organizations in different sectors. But today, what I kind of wanted to bring to the floor is some of the results of some personal research that I have been conducting. So I'm putting on my researcher hat, and what I would like to talk about today is technology when it comes to human rights supply chain monitoring, and what kind of opportunities and risks we can see when it comes to this particular trend. It is, the area of human rights is, of course, to some extent can be considered peripheral to economic crime, but as many of you are probably already aware, there are some extremely interesting developments happening in the space of human rights that are leading to some degree, a kind of overlap between the ways that we would normally traditionally conceptualize economic crime and human rights. And so what I have experienced in the past, particularly as compliance specialist, is that working in the business and human rights space, you're starting to see that actually a lot of energy and a lot of focus is going into tackling human rights violations. This is pushed from consumer activism, but also investor activism. There's a series of internal and external drivers that are moving this trend such that we can kind of say that human rights is sort of the anti-corruption of 10 years ago. So it's really gaining a significant importance for companies. So there we go. When it comes to the area of business and human rights, there has been a significant shift from treating this area as a sort of nice to have, best practice, responsible business conduct approach to really becoming a mandatory area of law. So what you're starting to see across the board with several multinational companies operating in different sectors is that they're starting to treat human rights as a de facto area of compliance that requires the same kind of internal measures and mechanisms, compliance programs that maybe other traditional areas of compliance have always had, such as antitrust and anti-corruption. And what is mainly driving this shift is, I would say, also developments in the legislative space. So very briefly, what we're starting to see both at national, local level, but also at international, regional level, is a transition from best practice guidelines that are soft law, not mandatory for companies, considering that companies have traditionally been considered as non-state actors, as not being subject to international conventions on human rights. This is now really starting to change. And we can say that local legislators have really moved this trend forward, particularly the US with the Global Magnitsky Act, but also various companies within various countries, within the EU have been really driving this shift by adopting legislation that effectively creates obligations for companies to monitor their supply chains for human rights abuses. And at the risk of incurring sanctions, whether civil administrative sanctions, for failure to comply with these obligations. Now, some of the legislation I've mentioned here really touches on different areas. We've had legislation that creates blacklists, for example, so traditional financial sanctioning mechanisms that are being used for companies that violate or contribute to human rights abuses. But this also goes into the space of trade, for example, creating barriers to trade where companies cannot prove that the products they want to insert into a market respect certain ESG standards, and a particular focus on human rights due diligence. So perhaps no area has been as active in the last few years as the European Union on this. And what we have seen quite recently is a significant piece of legislation that many business and human rights specialists think are really going to change the landscape when it comes to compliance on the part of multinational companies in particular, and that's the EU Directive on Corporate Sustainability Due Diligence. The Commission proposed this, a text of this directive in February last year, and it is currently passing into the trilogue stage. So presumably between this year and next year, we should see some definitive outcomes when it comes to this directive. In brief, because time is of the essence, what this directive would do is create hard obligations for companies, and a series of companies will be included within the breadth of the application of this directive. As you can see here, companies that are operating in the EU or established in the EU and meet certain thresholds will be required to comply with the obligations foreseen in this directive. And that includes identifying, preventing, mitigating human rights abuses, as well as bringing them to an end, and taking specific measures also to communicate what efforts they're making when it comes to mitigating human rights violations in their supply chains. Now, where technology can become particularly relevant is when we look at the scope of application of this directive. And what the directive for the moment says, and we'll see how this develops throughout the trilogue negotiations within the Parliament and the Council of the European Union, is the nature of the value chain and how that's defined. So at the moment, companies are obliged to respect these obligations relating to human rights due diligence and monitoring their impact on human rights in their own operations and in the operations of their subsidiaries. Not only that, they are also required to carry out these obligations when it comes to their value chains, quote unquote. Now, there's been a lot of debate about what constitutes a value chain, and the directive defines a value chain in very broad terms from a company perspective in particular, as it includes both direct and indirect so-called established business relationships. Now, what this is leading to for companies is certain obstacles that companies have been voicing when it comes to public consultations on this law. And that is particularly this: how are we meant to monitor the behavior of suppliers when our global supply chain can include thousands, tens of thousands of suppliers, be they direct or indirect? And it's very difficult for companies to know exactly how these suppliers are behaving. And so when it came to the public consultation, what companies said was, let's try to limit these obligations to something that's more feasible. And very often, one of the reasons that maybe would come up in these discussions, as well as in legal analysis by law firms, et cetera, was the fact that extending these obligations to the entire supply chain of a company would create considerable economic and administrative effort for companies that just isn't reasonable in the circumstances. And this is where technology can become very interesting to monitor. And my presentation essentially wants to say, watch this space, because I think this is going to become extremely relevant, looking at the developments in technology that we're seeing over the past 10 years, but particularly this year with the publication of certain AI instruments, making them accessible to the public, but also developments in legislation when it comes to business and human rights, is that maybe this position that, you know, monitoring the supply chain is an extremely difficult task when you're talking about direct and indirect suppliers, tier 1, tier 2, tier 3 suppliers. This is maybe no longer going to hold ground when we can see the technological and digital tools that are going to start becoming available, that already are available for companies to conduct these kinds of monitoring activities. I've cited some here. Blockchain is one that has already been applied over the past decade, we can say, and essentially consists of applying unchangeable data to a particular product, which gives you the ability to have real-time information on where the product is, every step in its life cycle, and whether that product is respecting certain ESG standards. So this enhances transparency across the supply chain, and makes it much easier for consumers to know where their products are coming from. And this can also help companies provide, particularly when it comes to certain trade-related obligations. Trade-related legislation often requires companies to provide traceability of where their products came from. And having blockchain technology applied to this can be extremely useful for companies to prove that their product is coming from a, let's say, a human rights violation-free space. Artificial intelligence, extremely hot right now, takes data organization and processing to a completely new level. It can pull very high and consistent levels of data. And this is something that companies have lamented in the past, that they don't have data on their suppliers' compliance with ESG standards. This is now probably going to change with artificial intelligence, also in the legislative analysis space. So keeping up with this consistent evolution in business and human rights legislation can also be a way where artificial intelligence is potentially going to replace the work of us lawyers in this space. Not to mention, it seems less relevant when looking at the grander scheme of things, but I think it's a very important one to state, is translation and educational enhancements. There are platforms, applications that are now allowing cultural and educational barriers to be completely broken down, because irrespective of the language, of the level of education of the person, it is becoming easier and easier to communicate, and also therefore to collect data when it comes to conducting human rights impact assessments, for example, on-site investigations into a company's supply chain. This is really going to be relevant as well. So I put here an example. This is what we're starting to see, is companies that are actually providing upon payment human rights due diligence tools, and they're digital, and they're really relying on digital technology to conduct what they call as more accurate, more efficient, more resourceful human rights due diligence. Very briefly, opportunities and risks, and this is really just something that is more food for thought than perhaps a prediction of the future, but some elements where the use of technology can constitute both an opportunity to risk are some of the ones that I have listed here. And for starters, technology and digital tools can allow a consistent and streamlined yet tailored methodology across all regions. This is a significant advantage, particularly when it comes to those kind of cultural barriers that we mentioned earlier. What technology can do is really apply it across the board. But the concomitant risk linked to that is the fact that digital human rights due diligence can risk becoming a bit of a desk-based exercise, which is already the case without technology. Very often there are surveys that are sent to the location, questions that are asked, but without on-site inspections, it's very hard to really know what is going on in loco. So when it comes to digital human rights due diligence, where it may fall short is the fact that human rights due diligence is very individual focused rather than company risk focused. It's premised on having a meaningful engagement with all stakeholders potentially affected by a company's operations. So the question that arises here that I leave open is, how important is the human element when it comes to conducting human rights due diligence activities, which are so the examples are human rights impact assessments, but also handling a grievance mechanism. To that extent, there is a sensitivity required also when conducting these activities that technology might not be able to provide. Secondly, human rights due diligence in terms of an opportunity, when used in the digital space, it is really based on what is called a risk-based approach. So what this means is that for human rights due diligence, it's very important that certain areas most at risk are prioritized over others. This doesn't mean that we ignore the areas that are less at risk, but that we devote resources depending on where the risk is higher, and then we work our way down. What technology can do is help us create extremely efficient and effective strategies of prioritization and targeted intervention, thereby maximizing resources. But of course, on the other hand, a related risk is that technology, particularly AI, is showing a propensity towards efficiency. And we're not entirely sure whether that might conflict with the nuanced and people-centered approach that is required for human rights due diligence. So we'll have to see how digital human rights due diligence, what type of criteria will be used to conduct it, and how to ensure that it remains people-focused rather than company risk-focused. And then finally, two elements is one that Costantino mentioned as well, which I think is extremely important, which is the fact that technology is seen as providing a certain level of objectivity, allowing approaches to tackling human rights abuses to be based on data and hard evidence. So, and being proactive rather than reactively relying on reports that are made, complaints, or bad press on a particular operation by a company. This isn't necessarily always the case. There is digital bias. Technology is developed largely by Western, white, able males, and this can lead to technology not always being neutral. So that can present human rights risks in and of itself when we're talking about algorithmic bias. And then finally, breaking down cultural barriers is something that I've mentioned also previously, but this can only happen where access to technology is equal across the globe, which at the moment it is not. So we'll see throughout this lens of opportunity and risks, we can see how technology, having the awareness, something that Costantino also correctly pointed out, having the awareness of these potential risks might allow us to tackle before the issues actually arise, tackle any potential shortfalls or shortcomings that might come with the use of applying this technology when seeking to perform our human rights due diligence obligations as companies. Thank you very much. This concludes, I hope I stayed within the time. This concludes my presentation, and I look forward to hearing everybody else's thoughts. Thank you.